Less than 12 days to the governorship election in Bayelsa State, the Court of Appeal Abuja has reversed the nullification of the candidacy of the All Progressives Congress APC Timipre Silva. In a judgment delivered on Tuesday, the appellate court held that Justice Donato Sokorowo of the Federal High Court was wrong in ordering the sack of Silva as a candidate of the APC in the November 11 governorship election in Bayelsa State. According to the court, the trial court was aired in having assumed jurisdiction in the matter on grounds that the plaintiff at the Federal High Court lacked the necessary locus standi to initiate the suit in the first place, having not participated in the primary election that produced Silva as the flag bearer of the APC in the forthcoming election. The appellate court said the issue of jurisdiction is fundamental in an election matter, and since the lower court had no jurisdiction in the first place, all actions taken in the matter are declared a nullity. Justice Zubero also awarded a cost of 1 million naira in favor of Silva. Well, to speak more on this court judgment, legal practitioner and political affairs analyst Evans Ufeli joins me on the news. Thank you very much for your time, Mr. Evans. Now, what do you think about the ruling of the court?
Yeah, the ruling of the court is predicated on law. If you look at the Electoral Act, I think in section 29, it clearly states that if you have to challenge a party who contested an election, whether primaries or otherwise, you need to have the requisite local standard. That is the good ground to make that a challenge. You have to be a participant in the election. Okay? In the case under reference, the parties who went to court were not parties to the primaries. And so the Court of Appeal have just ruled that they have no local standard to so do. You know that the Federal High Court, before Justice Nicholas Owebu, had ruled at the Court of First Instance that based on Section 182 of the 1999 Constitution as amended, that Timipre Silva was not qualified to have even contested the primaries. So he went further to talk about the issue of the fact that he had been a governor 2 times. Okay, and if you read the Constitution very well, you find out that Timipre Silva did his first term, the second term was truncated. Okay, now because it was truncated, the court interpreted it to mean that if he is allowed another 4 years, it would mean that he would have stayed more than, he would have done more than 8 years, which is required by law. But the Supreme Court is saying the issue under reference is even that those who went to court does not have local standard. And that Section 182 of the Constitution clearly says that if you win election, okay, if you have stayed a little bit and your election was cancelled or by the court ruling invalidated, it does not account to mean that you have spent any time at all, even if you have done 3 years. So the Court of Appeal have put the record straight. So we're looking at what next action the parties are going to take in the case on that reference.
All right, briefly now, Mr. Evans, what impact will this ruling have on the electoral laws and guidelines?
The impact it has in the electoral law and guidelines is that this particular ruling, the court have ruled similarly in electoral cases where a party who did not, before now, the Electoral Act 2010, anybody can go to court to challenge the qualification or otherwise of a politician, whoever a candidate, okay? But the 2020 Act, okay, Electoral Act is the current one, now shrunk the jurisdiction, shrunk those who can do that. And I've said that it's only participants, okay, those who contested. So when you now want to challenge the validity or qualification of a candidate and you are not a participant, you're never a participant in the election, you have no locus. So the court has no jurisdiction to so determine that. And that is what the Court of Appeal has restated. That is the implication.
Legal practitioner Evans Ufeli, thank you very much for weighing in on this matter.